Yes. Hi. Howdy, everybody. Good morning, good afternoon, whenever it is for you. For me, it is morning, and I wanted to say hello to all you out there who are joining this morning. I see, again, Mr. StreamYard. I don't know if anybody gets that joke, by the way. On my screen, I see StreamYard, so I say hello to Mr. StreamYard. Born Free Films, The One, Market Watcher, Donald Lynn, Jim, Rondell, Toe Cramp. I like Toe Cramp, by the way. Splat One, Renee Dennis, or if I'm not pronouncing it correctly, I apologize. And to everybody else, Pete the Greek, whoever else shows up, appreciate it. Greetings. Hope everybody's well. Hi, Tim, by the way. I just wanted to talk about Ziggy, Northern Nice Guy, Lee. It's interesting. Hi, everybody, wherever you are. Wonder where everybody is from. Maybe sometime next time you can kind of indicate where you're from, because I'd like to see where everybody's from. Kilvey. I can go on all day, but to all of you out there, greetings and good morning, afternoon, evening, whenever you wanted to watch this. So what I'm going to do today is kind of report on the hearing that happened yesterday. The hearing was in GTII. I watched the entirety of it, so I feel comfortable talking about it. And we'll talk about what happened and what's the next steps and where we are, etc. Before I go on, I kind of just wanted to just be clear. I don't like to take credit for things that I'm not deserve credit for. So I just wanted to be sure that everybody understands kind of what my role here is, and I want to give credit to those who really deserve credit. So my involvement obviously started in 2020, late 23 and 24, helped push it forward. Obviously, I kind of called them out. That ended up resulting in the lawsuit and the receivership, etc. Once the receivership was set up, though, most of the push has come from the Receivers Council, and notwithstanding whatever difficulties I've had with Receivers Council, the Receivers Council has been responsible for pushing this forward and getting the relief that we've gotten. So the credit for that belongs to the Receivers Council. I just try to be kind of a pain in the ass and make sure to push things forward and make sure to kind of reflect what I'm thinking, and hopefully that's reflected in what they do. But they're responsible for all the legal work, and they're representing, the receiver, and then they have separate counsel representing the plaintiff. I'm just here kind of pushing it along, not representing anybody other than myself, but obviously my interests lie with everybody else, as you know. But I don't want to take responsibility and credit for everything, because there's plenty of other people involved, just to make the record clear. And before I go forward, I had like a few things to just quickly reference. I've heard all this discussion about Otto Penn, and I don't know who this guy Otto is and who he works for and where he's located and why everybody's so concerned about this guy Otto. Anyway, that's one. Yesterday, and I didn't get a chance to reference it, a truck, because there's a freeway behind me that you can't see. It's not that close, but it's not far. A truck loaded with Vicks Vapor Rub overturned on the 101 freeway, which is the freeway out there. And but amazingly, even though the truck overturned, there was no congestion for 8 hours. Hope you got that one. Never leave home without a kiss, a hug, and I love you. And then remove your dog's hair from your mouth as you walk to your car. And last but not least, I'm at the age when the term picking up a hottie at the club means getting rotisserie chicken at the Costco. Anyway, just wanted to say, I'll answer that first question. That's interesting. Sweet and sour. Appreciate the question. It's an interesting question before I start. Do you think that, so if you invest in a company and you get screwed, so I'm going to reinterpret the question, does that does that cause you to hesitate to invest in companies? It should cause you hesitation. You should reflect more and you should think about it. So I think it's a fine question to ask. I don't know how it's going to work because I think GTI is. So this is the question, not what I had planned to answer, but GTI, if it exists and it survives, will not be under the management, will not be the same business or lack of business that it was before. So people who will be investing, I think a lot of them would be people who are interested in the new business, not necessarily existing shareholders who may be interested also. I think it'll be a whole new group of shareholders that would be interested. That's presuming that the deal gets finished and it everything goes great and etc. So we'll have to see how that part works out. But in effect, it would be a totally different business company and not the same management. Obviously, or at least I don't know if it's obvious to others, but if the existing management remained, I would not be too keen on GTII. That's my little point there. So thank you for the question, though. So, and that was a left eye. I read it with the left eye, not the right eye. So I could see it. So I appreciate it. So kind of what I want to talk about was a little bit, and if I can see any other questions that are relevant, or at least that appear relevant to me, I'll kind of jump on them if I could see it. So there was a hearing yesterday. The hearing was in Vegas. The hearing was about the receiver's motion or objection to a bunch of illicit shares that they claimed they gave the label as illicit. And it's in the motion. I think it's in the last fourth receivers report. We went through all 87 of those entities. I think I literally just named them off and share counts, etc. So yesterday there was a hearing, and it was on shortened notice, so it wasn't full notice. And basically, the hearing was two parts. One was to get a freeze order. So in essence, that all those shares that are being contested, and it's about 178 million shares, that they couldn't be transferred or sold, etc. And we've all seen some activity and share activity involving GTII, and it's small numbers, but there is trading activity. We don't know if any of these are the ones who are selling the shares, but now they're in the order. I don't think has, even though the court ruled and is going to rule, I don't know if the order is in effect. Some of them think that the receiver's initial order covered it. This will be double covered it. And then until there's some adjudication of the owner, adjudication means some decision about the ownership of those disputed shares, then they'll kind of remain stuck and nobody will be able to sell them, which is a good thing. I expect, kind of based upon the hearing yesterday, and I haven't got into the hearing yet, but I'd expect, based upon the hearing, that a bunch of those shares will be returned without the need for litigation from various parties who have gotten them. But I do believe, based upon yesterday, that at least at this point in time, and that could change also, that Reichman's both, that Kathy Griffin, and that Frank Benintendi, not the same Frank, I'm sorry for Frank, may also all four be contesting it. There might be others, but those four seem to be contesting it. The reason why I suggest that, because those four all were in attendance at the hearing yesterday. I don't believe, of the other 87, I don't think anybody else appeared. But there may be some others that object. But I think a lot of those are going to roll over and return shares, which I'm sure will add up to a significant amount of shares, but not the biggest amounts, which are with the people. So yesterday's hearing was part of that freeze motion. And as to that, there really wasn't much opposition to that from anybody. And so the court granted the freeze. So the freeze will go in effect officially once the order is signed. And I expect the order will be submitted shortly, hopefully today, and it'll be probably signed shortly after that. Once it's signed, no one will be able to trade those shares, or they'll be in violation of the court order. And that will be the biggest amount of shares at issue. And originally, all of us, there's an ongoing, negotiations, and that was discussed at the hearing. There's, a target. AIversity is involved. And originally there was discussion about the need, in order for that deal to go forward, amongst other things, that all of the shares had to be returned. I think that has changed. I can't, say 100%, but my impression is that has changed. As long as those shares are tied up, the contested shares are tied up, then I think the deal can go forward without completion, or before all the issues about the shares are decided. I think that's the way it will work out. No guarantees, but that's kind of the way I see it. So originally, I think we were thinking about the steps that were required to complete a merger or acquisition, et cetera. Was it's got to be trading again. They got to complete the audit. They got to get all the contested shares back and money. I think that getting the audit done, getting it trading again, getting a business in, I think can all be done without the conclusion of getting all those shares back at this point in time. So I think that will be good. I don't think there's, by the way, I think there's a question about the float. At this point in time, I don't think the share count has been impacted by the freeze. The shares still exist. If there was cancellation of those shares, then the float would drop dramatically. And I think, that's hopefully in the best case scenario that would be going. But the bottom line is that one of the obstacles that appeared to be in the way of completing a transaction, that seems to be, and again, I can't vouch for anybody. It's not guarantees, not legal advice, not financial advice, but seems to me that one of those hurdles that needed to be overcome to complete the transaction will have been overcome. Not that all the issues about the disputed shares have been completed, but now there's some control over those shares, and there may have been control before too, perhaps, per the receiver's order. But now it's been established, and I think things can move forward. Of course, it's not the only thing. The audit has to be completed. It has to get trading again, et cetera. And the business, they have to complete whatever their arrangement is. And, there's no guarantees that all that can be done. But as far as I could see, everything is moving forward in that direction. Now I'm referring to any particular potential deal with AIversity. I think everything is moving forward at this point in time. So first part of the hearing was the freeze, and it came back. So discussed at first, and there were 4 attorneys. The attorney for the receiver spoke, then the attorney for Reichman spoke from New York. The attorney for Kathy Griffin spoke. I think the attorney for Justine Reichman spoke also, and Frank Benintendo for Benintendo. The way it was explained, and again, I'm not a Nevada attorney, but the way it was explained was what they did, and this is referring to what the Receivers Council did, is they looked at all the statutes that cover receivers, and they tried to use those statutes to create a method by which the receiver could challenge the nature of the shares, the illicit, dubiously. By the way, dubious came up in the hearing by the other side, so it was kind of funny because in the papers that were filed, it refers to dubious consideration on multiple times, and I made a joke about it, obnoxiously referring to it about 15 times during, but it came up. So the issue that so they're trying to create some kind of structure. So it's kind of not etched in stone. The response was by, I think, all 3 sides, and again, I think they had spoken to each other, so they kind of had a united voice, was they didn't want to be deprived of a right to a jury trial on these issues. They didn't think that they should be able to cancel the shares without them getting full due process. The judge seemed to be very cognizant of the issue of due process, and it came up a lot of times. And so the issue of discovery came up, and should they have a right to discovery, before they have to make their claim about shares. In the code, apparently, it does say that if there's a contested issue, that they have to submit something under penalty of perjury. So on one hand, all the defendants are saying we need access to the documents in order to figure out, what we need. On the other hand, the receiver's counsel basically said, and it's kind of what I would have said, you could submit a declaration under penalty of perjury, and you could say what your understanding is, why you have the legitimacy of the shares, and go from there. I think it's kind of in my mind, it's kind of dangerous for somebody like David Reichman to put himself forward on deposition because there's a great risk. And so in one aspect, they're asking for discovery. On the other side, I would say, if I was the receiver's counsel, come bring it to me and let me take David Reichman's deposition, let him get under penalty of perjury, and let's go from there. Let them submit and do the job that probably a lot of other people are looking for them to do. So the issue then becomes due process. And I kind of predicted, this is what I predicted before the hearing, and I think it basically came out. What I predicted was the freeze order was going to be granted, and it was. And then what I predicted, there was going to be some meet and confer about the procedures and the orders, and that's what the parties agreed to do. So the parties, it might have happened even yesterday, agreed to get together to discuss the proper procedures for dealing with shares that have been designated by the receiver to be illicit. And does that mean that they're entitled to discovery, or what kind of hearings are, who has the burden of proof? I think the burden of proof would still remain with the receiver, by the way. Is there any right to discovery, etc.? So that part of the motion, kind of the substantive part in terms of how the procedure would be going forward, that part is going to be heard again on June 18th. And in the meantime, the attorneys are supposed to get together and try to craft something together. On that 18th also is the date that the 5 attorneys who did not certify the audit, there's a hearing on that date, the same date, June 18th, that if they have not certified, they have to show cause why they have not certified. And if they don't, then they could be in contempt. A method just to try to get the final certifications done so that the audits can be certified and done. And again, as far as I know, and I've mentioned this a few times, as far as I know, the only thing that's holding up the audit is those certifications. All the work has been done. And in listening to the hearing, by the way, so the freeze, I think, stands for itself. And again, I think it's helpful for proceeding forward in the way I understand it. The rest of the motion concerns the procedure by which the shares are going to be decided. If that's done by trial, then so be it. If it requires the deposition of the principals, so be it. I've expressed my reluctance that the principals, being the Reichmans, etc., will participate in good faith in mediation. And if they're not willing to do that, then I would just forego that for the time being and proceed with discovery, take Reichman's deposition. Again, just make them put this under penalty of perjury, put these people to the mat, make them have a risk, make them have the risk. If what the receiver claims is true in all his reports, then it would be a big risk. And again, I think an unwise decision to voluntarily testify at a deposition, in my opinion. But again, I don't know what they're going to say. I don't know what the facts are. I don't know if the receiver's reports are correct. But either way, either they'll figure out a procedure that will take care of this, or it'll go to trial, or through something called a motion for summary judgment, and it'd be adjudicated. And most of the other shareholders of the 87, I think, will be taken care of. Certainly the ones that are independent of Reichman, et cetera, will be taken care of, I believe, long before that. So there'll be a bunch of those shares will be recouped. I think they will be canceled. That's my understanding. but we don't know yet. And obviously, to the extent they're canceled, that reduces the float. So all that would be good. But we'll know more on the 18th, I think, what the process will be. In the meantime, I expect that the parties will continue to negotiate on the merger and complete whatever steps are necessary. And I presume the Receivers Council will move forward with getting the audit done and getting the certifications completed. Again, I expect on the 18th, which is less than 2 weeks away, that we'll know more in terms of the audit and this issue. But in the meantime, the freeze order was issued, and that was very important. And I think we're just moving ahead. No guarantees. This could certainly flop. The deal may not go through. All possible. But so far, from where we were, let's say January of 2024 till today, if you're a stock fan, it's been up and to the right. And if we can continue that and there's not a big pullback, then I think we're headed in the right direction. But we don't know. Anything can happen. And we'll have to see. We'll see the paperwork as it comes in. I'm on the service list, so I get all the paperwork. And so as all the paperwork comes in, and that's different than the past when I wasn't on the service list since I was represented. But as the paperwork comes in and I see details or events or things that are important, I obviously will keep you all apprised and let you know. And we'll have more of these get-togethers. Just as a side note, I have started a new channel. I have a new channel. I haven't really started it, but I will start doing it kind of like a regular, that's the idea, a regular nightly news review called Not the News. And not, you can guess how not is spelled. And I'll probably do that starting, I think the plan is to do it every weekday at 8 Eastern, and it'll be my take on the daily news. I'm kind of a news junkie, so maybe it'll be of interest to somebody out there. You'll see it. Remember, Not the News, KNOT. Anyway, for anybody else out there, if you have questions when you see this afterwards, please put them in the comments. If I can answer anybody's questions, I shall. I do look at everybody's stuff. You will see. You'll see some indication I've looked at it. I do look at everybody's. I appreciate everybody's comments. And if you have questions that I can help answer or can't help answer, please let me know. Everybody be well, take care, and keep up the good work, everybody. Let's keep it going. Let's keep the